Good afternoon, everyone, and thank you for joining us for today's webinar, Housing Discrimination and Your Rights. My name is Veronica Cortez. I am a Latina, middle-aged Latina. I have a ponytail and I wear bifocal glasses, and today I am wearing a very light colored green shirt. So thank you so much for being here today. Again, I am Veronica Cortez. I am a community navigator, fit project specialist with Disability Rights Texas. All right, so this is our roadmap for today's webinar. We're going to talk a little bit about Disability Rights Texas, the laws that prohibit discrimination in housing, reasonable accommodations, reasonable modifications, administrative complaints, our contact information here at Disability Rights Texas, and of course, our survey at the end of today's presentation. So let's talk a little bit about Disability Rights Texas. Disability Rights Texas is a part of the National Protection and Advocacy System. We do fall under the purview of the National Disability Rights Network. We were established through federal law in 1977. We are a nonprofit legal firm, and our job is to protect and advocate for the rights of Texans with disabilities because we want to ensure their equal participation in society. We do serve Texans of all ages and a wide variety of disabilities, including mental as well as physical disabilities. So, what do we do? We provide direct legal assistance to people with disabilities whose rights are either threatened or violated. We work to protect the rights of individuals and groups of people with disabilities through the courts and the justice system. We do have policy specialists on staff that inform policymakers about how issues impact people with disabilities. Our outreach team and various members of our staff help to educate people with disabilities, the community, and family members about their rights. And of course, we make referrals to programs and services that are local to our clients. Some of the areas of focus at Disability Rights Texas are alternatives to guardianships, such as supportive decision-making agreements, uh, powers of attorney. We focus on community integration, disaster preparedness and recovery. Education, our education staff focuses on early childhood intervention, as well as K-12 and college age students up to age 22. We focus on employment, employment and people's rights under employment, disability rights under employment, healthcare, housing, institutional rights and civil liberties, transportation, as well as voting rights. Excuse me. So let's focus on the laws that prohibit discrimination. So the Fair Housing Act prohibits discrimination in housing, and that's both at the federal and at the state level. Local fair housing laws. There are local fair housing laws that prohibit discrimination in housing. Section 504 of the Rehabilitation Act of 1973 prohibits discrimination when it comes to design and construction. And of course, the Americans with Disabilities Act. So we're going to focus on the Fair Housing Act, or the FHA. So under the Fair Housing Act, who has to comply? Well, property owners, landlords, housing managers, subsidized housing providers, HOAs, which are homeowners associations, as well as condo associations, real estate agents, brokerage service agencies, banks, insurance companies, the list goes on and on. But there are exceptions to this rule. For example, a row of townhouses that have all units that are 2 stories are exempt from the Fair Housing Act. That is because it is a 2-story domicile, which by definition will make it inaccessible for people with disabilities. Properties that were um, built for first occupancy before March 13th of 1992 are exempt from the Fair Housing Act. Anybody who has, let's say, a house that they live in, and then they have um, a rental property, they're going to be exempt from the Fair Housing Act. But of course, there are exceptions to those exceptions. Um, for example, let's take a person who owns their own residence and then has a rental property. They are normally exempt from the Fair Housing Act. However, if they advertise on any website like homes.com, zillow.com, uh, those kinds of websites, then they are going to be beholden to the Fair Housing Act. All right, so who is protected under the Fair Housing Act? We talk about them as protected classes, and that includes race, color, national origin, religion, sex, familial status, and disability. So under race, we're talking about race, African American, white, or Asian. That's the 3 races. Color, within races, there are a variety of skin colors. And so under color, the darker toned, residents, uh, or lighter skinned residents within any particular race is what we're talking about there. National origin simply means where that person may have been born or where their ancestry comes from. Okay, somebody who is, uh, let's say, Hispanic may have origins, their national origins may be Argentina, or they may be Brazil or Spain. Religion, um, anybody who practices any religion, whether that's the Christian religion or the Muslim religion, the Jewish religion, any religion or lack thereof. When we're talking about sex, we're talking about, uh, whether they're male or female and any discrimination that might happen based on that, their gender. Familial status simply is referring to having kids or not having kids. What is your familial status? Are you a one person? Are you single with no kids? Are you single with kids? Are you part of a 2-parent household with kids or no kids? That's what we're talking about when we're talking about familial status. And then, of course, disability is mental, physical disability that a person may have. So those are the protected classes under the Fair Housing Act. So who is protected under disability? Because we're going to focus under the Fair Housing Act on disability. So any person that has a physical or mental impairment that substantially limits a major life activity is considered a person with a disability. Any person who has a record of such an impairment is considered a person with a disability. Or anyone who is regarded as having such an impairment is protected under disability. And this is under the U.S. Code, Chapter 42, Section 3602H. So who else is protected under disability under the Fair Housing Act? Well, someone associated with a person who has a disability. For example, family members. If you are a child caring for an elderly parent who has a disability, or you are a parent of a child with a disability, you were protected under the Fair Housing Act under disability. someone who with a history of a disability. So I want to note that alcoholism, active alcoholism, is considered a disability under the Fair Housing Act and under the Americans with Disabilities Act. Now, former drug user, someone who is clean, someone who's gone through an addiction recovery program, who is in recovery, is also considered a person with a disability. Now, this isn't someone who's active in substance abuse or who is an active user. They are not covered. But if they are a former substance user who's completed that recovery program is considered a person with a disability. So if a housing provider or any other entity who has fair housing obligations thinks has a disability is considered a person with a disability or is protected under disability under the Fair Housing Act. So under the Fair Housing Act, there are some things that we are not allowed to do. So these are all going to fall under that same US Chapter 42, Section 36004. So refusing to rent or sell housing is prohibited under the Fair Housing Act. Refusing to negotiate for that housing is prohibited under the Fair Housing Act. Making housing unavailable is prohibited under Fair Housing Act. Setting different terms, conditions, or privileges for sale or rental of a dwelling are prohibited as well. So providing a person different housing services or facilities than a person without a disability is not allowed under the Fair Housing Act. So let's talk about a few examples here. So refusing to rent or sell housing, negotiate, or making housing unavailable. So if let's say a landlord advertises their rental unit, and they receive a call from a person, yes, absolutely, this house is available. And when that person shows up, they're a member of that protected class. Maybe it's a person with a disability. The landlord cannot then say, oh, no, 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 this is not available. I'm so sorry. You must be mistaken. So that's making that housing unavailable. Okay. Um, Providing a person different housing services or facilities. Um, so an example of that may be, you can only use the laundry facilities in X building of the complex. Um, when everyone else in the complex is allowed to use whatever laundry facility they choose to. Okay. And we'll talk about different terms and conditions in the following slides. So what else is prohibited? You cannot make any ads or statements or have any notices that show a preference, limitation, or discrimination in sale or rental. And that's, again, under Section 42 of the United States Code, 3604, this time C. So client lives in an apartment. Okay, she uses a mobility device, and someone uses the language of akin to, she's not supposed to be in that apartment due to her disabilities, or words to that effect. And this actually really happened. And if you follow this link, there is a lawsuit that was filed with the Department of Justice. This actually happened in Beaumont, Texas. Okay, so making ads, statements, or notices, for example, you cannot make an advertisement for your rental unit that shows a preference to someone with no kids. Okay, you can't make any statements or notices that say no Muslims allowed or no Christians allowed. Making a preference that says single white males only. Those are prohibited under the Fair Housing Act. So here are what the Fair Housing Act prohibits when it comes to terms and conditions. So you cannot use different qualification criteria or applications for the sale or rental of a unit. You cannot have different procedures, such as income standards. You can't have different application requirements or application fees, credit analyses, or a sale or rental approval procedures. So, qualifications, criterias, or applications can simply refer to things like you have to have you're a member of a protected class, and you have to have a credit score of 720 or better when their normal course of business only asks for a 600, credit score. Procedures such as income standards. You cannot require, let's say, somebody with a disability to pay twice or to have twice the amount of income standards that is normal, which is three times rent. Let's say a person with a disability, you can't say you require five times income, as rent, five times rent in your income. So you can't have those different income standards. And this is true for any one of those seven protected classes. Application requirements. If you don't require someone without a disability to give you 10 letters of recommendation or references, then you can't expect someone with a disability or be a member of the seven protected classes to have that requirement of 10 references. Application fees. You can't charge someone who's a member of a protected class more fees to apply for that rental or sale than you would a person without being a member of those protected classes. We talked a little bit about credit analyses and then approval procedures. We want to make sure that everyone has the same playing field and not be discriminatory against people of those seven protected classes. So, what can you not do? Well, you can't evict a tenant or a tenant's guest just because they're a member because they have a disability or a member of the protected classes. And this is under US Code 42, Section 3604A and F1. You can't harass a person. You can't fail or delay performance of maintenance or repairs because they're a person with a disability or they are a member of a protected class. You can't limit their privileges, services, or facilities of a dwelling. And you can't assign a person to a particular building or neighborhood or section of a building or neighborhood. So let's take each one of these and let's see what that looks like. You cannot evict a tenant or a tenant's guest because they're a member of a protected class or because the renter is a member of a protected class. Okay, so if you have a tenant with a disability and they're having a home health aide come in, you can't evict that tenant for having that guest in their dwelling. So you cannot you can't discriminate against them for that. Excuse me. Don't know what I just did. Please excuse me. Oh, goodness. Okay, I am not sure what happened to my screen. Share that screen, and it is not sharing for whatever reason. So I'm gonna oh, there it was. All right, my apologies. All right, here we go. So you cannot evict that tenant or that tenant's guest because they are visiting and they may be a member of that protected class. You can't harass a person. Your neighbors can't harass you because you're a member of a protected class, including disability. If a person is a member of those seven protected classes, then you can't fail or delay their maintenance repair, requests or repairs. Limiting privileges, services, or facilities, you should not tell a tenant who has a disability, for example, that they can't use the pool or that they can't use the clubhouse because they are a person with a disability. And then you cannot assign a person of a particular protected class to a part of a neighborhood or a building or a section of a building. So, for example, if you have a um, someone who is wanting to rent who is a person with a family, let's say it's two-parent household, they've got three kids, you cannot put them, all of the families with kids, into one section of a complex or a neighborhood for that matter. So all of those things are what the Fair Housing Act prohibits. All right. So under the Fair Housing Act, we cannot tell a homeowner that people of a particular protected class are going to move into the neighborhood to get them to sell so that the buyer can make a profit. Okay, so you are a real estate agent, and you've got potential buyers, and you say, or the sellers, you really want to sell now because this neighborhood is going to get kind of dark. Those are very discriminatory words, and they are prohibited under the Fair Housing Act. Now, you cannot do any of the things discussed here in connection with homeowners insurance because of the protected class of the owner and or the occupants of a particular dwelling. And we've seen lots of stories in the news where, particularly people of color are having to change the way their house looks. So that when the insurance agent, comes in, they're not saddled with higher premiums than someone who's not part of a protected class. And then you cannot deny any access or membership in any multiple listing services or real estate brokers organizations. So we want to make sure that we understand that when we have MLS listings denied for someone who wants to purchase them because they're a member of a protected class. Okay, so anybody anywhere who has the funds to access membership to any MLS service or broker, real estate brokers organization services, you can't do that. You can't deny that. They've got the means to purchase, they should be able to purchase. All right. So, a little more under the Fair Housing Act that we cannot do. We cannot threaten, coerce, intimidate, or interfere with anyone's residency, okay, in their unit. And this is all of US Code, Chapter 42, Section 3610, if you'd like to read more about that. All right, so we're going to move on to requests for accommodations. So, so an accommodation is nothing more than a change to a rule or policy or practice or services that a housing provider uh, gives. Okay, so they must make reasonable changes to rules, policies, practices, or services when that change may be necessary to give a person with a disability the opportunity to use and enjoy their home just like someone without a disability. Okay. So requests for accommodations don't require any special language. Of course, it's better to put everything in writing. If you visit our website, drtx.org, you will find letter generators requesting accommodations from your housing provider. So a request for accommodation, uh, that change is necessary so that that person can enjoy their home. just like someone without a disability. Okay. So what is reasonable? Because it's a reasonable accommodation. So what is reasonable? An accommodation is reasonable unless the change, exception, or adjustment imposes an undue financial hardship or it alters the nature of the provider's operation. So, a brief example of what may be considered reasonable, maybe. Someone who is needing a service animal. You know, they are blind or low vision and they have a guide dog. The apartment complex has a no pet policy. So a reasonable accommodation can be asked uh, because the person with a disability requires that service dog so that they can enjoy their dwelling. That does not impose an undue financial and administrative burden to the housing provider. And it doesn't alter the nature of the provider's operations. So, if here's a caveat though, they may ask you to pay a pet deposit. And unless you are unable financially, because it would be a financial burden to you, they should be able to waive that fee. However, if you are of means and you are able to pay that pet deposit, then we would say that that is an obligation that you need to pay. Um, an example of what does impose an undue financial and administrative burden. Let's say you are a person with a disability and you want your apartment complex to vacate all of the units around you because you don't want to hear any noise. Well, that's not reasonable because that's going to impose that undue financial hardship on the apartment complex because they're not going to be able to rent the adjacent units. Okay. When it comes to altering the nature of the provider's operations, let's say everybody has to take their trash out to the trash dumpster. You are a person with a disability and you are asking for an accommodation for, the agents in the office to come and pick up your trash and take it to the dumpster. Well, that kind of alters the nature of the provider's operations because it's not part of the way they do business in picking up everybody's trash to take to the dumpster. So that person would more than likely have to find an alternative to that, to having the agents of the apartment complex do that for you. Now, I am happy to answer any questions in real time. If you've got any questions, feel free to just interrupt me, and that I'd be happy to answer any questions you might have. All right. So the other part of a reasonable accommodation is it necessary? So what is necessary in a reasonable accommodation, it's the reasonable or the necessity helps minimize the symptoms of the person's disability so that they get to live in the community. So that low vision or blind person who needs the service animal, the guide dog, well, that's going to help minimize the symptoms of that person's disability, and that's going to allow that person to live in the community, which is where we want people with disabilities to live. We want them to live in the community because they're a very integral and important part of the community. So we have to make sure that accommodation is necessary. So to give you another example about necessity and something the accommodation being necessary. A person is let's say there's a person who lives in a dwelling in a unit and their medication requires refrigeration. Their refrigerator goes out. Okay. And they are requesting a refrigerator that has, let's say, a bottom drawer refrigerator or freezer for them to be able to get into, lower shelves in the refrigerator compartment that they can store their medication. And the apartment complex says, well, that's not necessary. Well, but it is because their medication needs to be refrigerated. So therein lies the necessary portion of that reasonable accommodation. All right, when we are asking for a reasonable accommodation, we always want to enter into the interactive process so that the provider and the person requesting the accommodation engage in that conversation. And if there are any questions about the disability related need, and if there are possible alternatives, or if the request is unreasonable, that dialogue needs to happen. So let's say, for example, we're going back to that refrigerator. The person needs a refrigerator to store their medications. And this time, this person says, well, I want the Samsung 5000, and I'm just making the name up, refrigerator that has the panel where you can see what's inside without opening the refrigerator door, and it connects to my telephone. And the cost of that is about, five, $6,000. Well, in the interactive process, it may be that the housing provider questions the disability related need because the disability related need is the need to refrigerate the medication. So the housing provider may come back with an alternative that says, look, I'm willing to get you this really nice LG. It's got a bottom freezer, it's got lower shelves, but it doesn't have all the bells and whistles that you're asking for. Then it is absolutely important for the person requesting that accommodation to engage in that dialogue. And if they're amenable to that alternative because it does meet their disability related need, that may be what it is that they get. The person requesting the accommodation can't dig their heels and say, no, I only want the Samsung 5000 or nothing else. In that case, they're not really in that interactive process. And it's absolutely reasonable that the housing provider can deny the reasonable accommodation for that particular refrigerator. Okay, so I hope that makes sense. Are there any questions so far about the reasonable accommodations? All right. All right, so let's talk about some request examples when it comes to accommodation requests. In Martinez by Martinez v. Lexington Garden Associations in the Southern District of New York in 2018, they came up with a ruling where someone could request an accommodation to ignore their rental history and their poor credit. So this is because it is disability related. So let's take into account COVID. And there were a lot of people who were ill and who were maybe hospitalized and maybe were evicted because they couldn't pay their rent and that went on their credit. Because it was disability related, um, we can ask for an accommodation, a reasonable accommodation, to ignore that rental history, that eviction because they were hospitalized or they were too sick to work and they couldn't make that rental payment. And same thing with their poor credit. We can ask for an accommodation to ignore that poor credit due to disability reasons because that ding in that credit report was due to the fact that they were evicted due to that disability. We can ask for an accommodation to hold off on filing an eviction. And this is true when rent is late. Okay. Let's say the tenant is a month late and they're about to file for an eviction. We could ask for a reasonable accommodation to hold off that eviction because there may be a way that tenant can pay that past due portion so that they don't file that eviction on them, or they can come up with a payment plan as part of that accommodation request so that they're not evicted and they can move forward in paying their rent. Having a cosigner when you apply for a unit. Maybe, the apartment complex that a person with a disability wants to rent has a no cosigner. There is no option for a cosigner. We can ask for an accommodation to bend that policy, to change that policy because of this person's disability, to have a cosigner for that unit. And change in rent due date. Many of our clients they have a fixed income and they are receiving their Social Security checks. And Social Security no longer just comes on the first of the month. You could be on the first Wednesday, second Wednesday, third Wednesday, like my husband, or the fourth Wednesday. And that that is a burden for the tenant, for the client, because their rent is due on the first and their fees start on the fourth. If they don't get paid till the second or third Wednesday, then they're racking up these late fees. And so we can ask for a reasonable accommodation to change the rent due date to correspond with when the client or when the person receives their funds from whatever entity they receive those funds from, so that they're not blowing their entire check in late fees and penalties. So we can ask for that accommodation to change that rent due date. All right, let's talk a little bit about direct threat. So the Fair Housing Act does not cover someone who is a direct threat to the health or safety of other individuals, or whose tenancy would result in substantial physical damage to the property of others. However, we can request an accommodation. So, and that's under US Code 42-3604 F9. In Heinart versus Wichita Falls Housing Authority, this direct threat was taken to court. And what they determined was that you can request an accommodation to this policy if there is a causal link between the behavior and the disability. Okay. Now, how do we request that accommodation? You can ask for an accommodation if that accommodation can mitigate the direct threat. There has to be an individual analysis that takes into account several things: the nature, duration, and severity of the risk of injury of that direct threat, the probability that that injury will actually occur, and whether there are any reasonable accommodations that will eliminate that direct threat if necessary. And that goes to the previous slide that says, will the accommodate, requesting that accommodation um, to eliminate, especially if there's that causal link. So on the screen is also the Department of Justice's and HUD's joint statement on reasonable accommodations, and that's available there. So we're going to move on to reasonable modifications. So reasonable modifications include structural changes to the interiors and exteriors of dwellings into any common and public use areas. So the question is documentation necessary? Well, if it's a visual disability, then that's not needed because the disability is obvious. But if that disability is not an obvious disability, it's a mental disability, it's a musculoskeletal disability where the person looks completely normal on the inside, they may need, those are the kinds of types that we're going to need documentation of necessity. documentation that says how this reasonable modification will mitigate and will help that person uh, uh, that enjoy the inside and the outside of their dwelling in common use areas. So, who pays? So, the general rule is that the tenant will have to bear the brunt of that cost. So that's the general rule. The other thing is that the landlord may ask you to put the unit back to its original state. Of course, there are exceptions. If the property receives any federal tax credits, it's a low income tax credit property, it's a USDA property, they may be the ones that have to foot the bill for those modifications. So it's always necessary to do your research and find out whether or not that property falls under that exemption. So the landlord or housing provider cannot, they cannot refuse to let that person with a disability change the premises if that modification is necessary to afford them full enjoyment of the premises. Except, again, if it's a rental, the landlord may require the renter to put the interior back the way it was before the change. So they may have to foot the bill, the tenant may have to foot the bill, and then foot the bill to put the unit back as it was before. And you can find that in, again, US Code 42, Chapter 42, 3604, F3A. So what happens next? You have gotten some, pushback because you're a member of a protected class. You are discriminated. You're denied housing for whatever reason, that we've spoken about. You've been denied your accommodation or modification. So what do you do now? Well, you can file an administrative complaint, and we're going to talk about what they are, who you should file with, and how. And note that with an administrative complaint, there is a 1 year statute of limitations. The other venue that you can take is filing a lawsuit against your housing provider. And that requires hiring your private attorney. You go to trial, and you adjudicate this in front of a court. Filing a lawsuit tolls a 2 year statute of limitations. It's important to note that these two venues can be taken at the same time. In other things like EEOC, you have to wait to get a right to sue letter. That's not true here. You can file an administrative complaint and file a lawsuit at the same time. So, what are administrative complaints? So, administrative complaints are simply a recourse for a violation of a person's right. And this goes through the legislative branch instead of the judicial branch. Okay. Now, when you file an administrative complaint, an agency is going to investigate. And during that investigation, the agency investigating is going to ask for more information. They're going to ask for supporting documentation, any letters, any text messages, any eyewitnesses or witnesses who can give information relating to that matter. And it's important to watch out for deadlines when you're being asked to submit something. So if the investigating agency says you need to provide witness information by X date, make sure that you are able to fulfill that. Now, you can always see if they can extend that deadline, but it's always best to comply with those dates. So what happens during an administrative complaint? The investigating agency is going to attempt to conciliate the matter. And that simply means that they're going to work with both parties to come to a solution. Now, if there's no conciliation, if there's no meeting of the minds, then that agency is going to decide if there's reasonable cause or enough evidence To believe that a discriminatory housing practice has happened or is about to happen. Or if they don't find enough evidence, they're simply going to no cause it. But you still have the option to file a lawsuit. So, where do you file these administrative complaints? Well, we can uh, file with the U.S. Department of Housing and Urban Development, or HUD, Texas Workforce Commission, Civil Rights Division, or any local city fair housing organizations. So when we file an administrative complaint with HUD, it's important to note that the Fair Housing Act does give HUD the authority to delegate these investigations to state and local governments, especially if they have a substantially similar law or ordinance to the Fair Housing Act. And it's, of course, always important to remember that there is the statute of limitations of 1 year once you file an administrative complaint. So, where do you file this administrative complaint with HUD? Well, you can reach out to them online to their online complaint in this link. Or if you cannot access their website because of your disability, you can submit by telephone, again, because of that disability. And the numbers are 800-669-9777. They do have a line for the deaf and hard of hearing at 817-978-5595. So, in the state of Texas, you can file a complaint with a Texas Workforce Commission Civil Rights Division. That is a state agency that HUD has tasked with investigating fair housing complaints. And you can email them at housingcomplaint@twc.state.tx.us. Or you can go online at their state of Texas link that you can fill out the complaint there online. You can also call at, by telephone at 512-463-2642 or their 888 number, which is available in Texas only because it's Texas Workforce Commission. And you can call them at 888-452-4778. Now, here's a pro tip. If you are representing the client, if you're assisting the client, if you are in any way in the picture with this complaint, ask the client to submit a letter that tells Texas Workforce Commission that you are representing that client so that TWC Civil Rights Division has that heads up. You can also file an administrative complaint via fax or mail. So you can fax your complaint at 512-463-2643. You can also mail your complaint to Texas Workforce Commission Civil Rights Division, 101 East 15th Street, and that is in Austin, Texas, 78778. So, if you feel that Disability Rights Texas is your best venue for receiving assistance, you can reach out to us at our statewide intake lines, which are available Monday through Thursday from 10 a.m. to 3 p.m. And that general intake line is 1-800-252-9108. If you require sign language assistance, we do have a sign language video phone, and that's available at 866-362-2851. We also have a Purple 2 video phone at 512-271-9391. DRTX also has an online intake form, and you can reach that at intake.drtx.org. So, how did we do? Please take our survey. So, please use your phone's camera to scan the QR code and let us know how we did. I'm going to leave this up just a few seconds for anyone to go ahead and scan that with your phone's camera. Thank you so much for being with us this afternoon. And please note that this work was provided for this publication, and it was supported by funding under a grant with HUD. The substance and findings of this work are dedicated to the public. The author and publisher are solely responsible for the accuracy of the statements and interpretations contained in this publication. Such interpretations do not necessarily reflect the views of the federal government. And with that, thank you so much for your time today. Have a great afternoon.